Good afternoon, everybody. Welcome to the Ways and Means Committee. It's Tuesday, March 2nd. We have 17 bills today. While that sounds quite long, not that many people testifying in total. We have 12 bills dealing with property tax or tax-related issues, 5 election law bills. So we're starting our day with the tax issues and ending with the 5 election law bills. We're starting with House Bill 1168, Delegate Fisher.
Thank you, Madam Chair and members of the committee. For the record, Delegate Mark Fisher, I have before you House Bill 1168 entitled Calvert County Personal Property Tax Exemption. The bill exempts specified personal property tax, as noted in the bill, in Calvert County only from taxation. It's actually more specifically, the bill states that after June 30th, 2020, but before July 1, 2021, personal property of a non-essential business, as described under Governor Hogan's order, his initial order, for any company located in Calvert County is not subject to the county property tax. So what that basically means is that if the governor of Maryland said that your business was non-essential, that you shouldn't have to pay property tax during that period of year. It seems kind of like it makes sense. So here's a great example. So in Walmart in Calvert County, they were open. And interestingly enough, there's a Hallmark store down the street that was closed, but Walmart sells Hallmark cards, among other cards too. Down the street, there's a GameStop that was closed. It was locally owned, I believe, but I'm not positive. But Walmart sells much of that same stuff. You can just go on and on and on, because obviously Walmart sells all kinds of things, as you can imagine, including in some cases groceries. But a lot of the stores that are the smaller stores that sold a lot of the same things were considered non-essential. That to me seems like it isn't fair. In fact, I know it's not fair. And I think moving forward, we need to make good by these particular small businesses, and we kind of need to make a statement. So this bill basically says, you know what, you're Walmart, you were essential, you got to pay. But if you are the smaller businesses and you were deemed non-essential, you do not. The bill is supported, of course, by the delegation. And to be frank with you, we're having ongoing conversations with our county commissioners. So with that, I would be happy to take any questions.
Delegate Fisher, I know you've had similar bills in the past, and I'm looking at the bill. Where is the language about the essential businesses?
That is, it's interesting. I had to call the bill drafter when it came back to ask that same question because it wasn't clear. It's on page 2, lines 24 through 27. And I had to ask the bill drafter the same question.
All right, thank you for that. Delegate Hornberger, question.
Thank you, Delegate Fisher. And I also have a similar bill that does this, which is a great idea. However, mine has a hold harmless clause and takes the money from the rainy day fund. And the reason for that is because, your county is going to miss out on that income, even though this was a state-induced problem, because that's where most of the personal property tax goes. So my question is there a hold harmless for the counties? I'm sure Mako probably won't like this one very much.
So no, there isn't. Okay. I think it's a great point, right? So in this particular case, Calvert County loses $2.3 million, according to the fiscal note, which I'm sure that the fiscal note writer probably just called the county and asked the budget director and others, and that's the number that they gave. Problem is that's $2.3 million that was paid by businesses who were closed. Right. And so your question is, well, how do you make up that money? And I think the same thing should be asked to the small businesses. How do you make up, the money of those small business people? And I think that on balance, the small businesses deserve this really. Keep in mind, the bill is just for 1 year. So, it's pretty straightforward. So, but it's a fair question, right? Because that's what everybody wants to know. It's like, well, where are they going to get
a great idea?
$3 million?
Definitely support the concept. Thank you.
All right, thank you. Any other questions for Delegate Fisher?
Of course, thank you.
All right, seeing no other questions, thank you, Delegate Fisher. We're done with the hearing on House Bill 1168. On to Delegate Brooks, House Bill 1175.
Hey, Chair Kaiser, Vice Chair Washington, and members of the Ways and Means Committee. For the record, I'm Delegate Ben Brooks. Thank you for the opportunity to testify before you on behalf of HB 1175. That's a property tax credit for disabled veterans, Act of 2021. The purpose of this bill is to establish a property tax credit system that allows disabled veterans to receive property tax credits on their home that correlates to their level of permanent disability. Currently, under the state law, we are operating on an absolute basis under which a disabled veteran in Maryland may receive full property tax exemption on their primary residence if the veteran is 100% disabled as a result of service. While this is extremely beneficial for fully disabled veterans, it does not offer any protection for veterans who suffer from less than 100% disability. This bill will allow disabled veterans to receive property tax credits for their home that parallels their disability percentage. For example, a veteran who is 50% disabled would receive a 50% property tax credit for his or her home. Yeah. Since this tax credit system is already established at 100% disabled veterans, it would not require or create a completely new system. We just need to create a scale for the tax credit rather than solely operating on an absolute basis. Washington County already has implemented this legislation on the local level under its 2018 ordinance. According to Washington County's Treasurer Office, there are 229 participants enrolled in at 0 to 100% disabled veterans tax credit program, and Washington County anticipate for FY22 a reduction of revenue of about $321,140. Yeah, this some of you on this committee are aware that I am a U.S. veteran who honorably served our country in Vietnam. You know, and like many of my comrades, I too have been afflicted by some of the hazards of war. Agent Orange is a defoliant that was used to remove leaves from trees and plants. This herbicide was heavily sprayed for tactical use from 1961 to 1991, and it subjected several troops to numerous medical complications and challenges, including cancer. While I commend the state in their current statute that recognizes the support of 100% disabled veterans, we cannot neglect other veterans who has less than 100% disability. HB 1175 rectifies this gap. Maryland residents whose military service resulted in some level of disability should be able to find comfort in the fact that the state of Maryland will lend a helping hand. This life of the life of a disabled veteran is hard enough without having to worry about whether or not, you know, they'll be able to keep a roof over their head. As a state delegate, it is my responsibility to advocate for all of my constituents, including those disabled who were disabled while protecting our country. For that reason, I request a favorable report, and I will entertain any questions that you might have.
Thank you, Delegate. Delegate Barnes with a question?
Yep. Thank you, Madam Chair. It's good to see you, Delegate Brooks.
Same here, sir.
Roughly, how many veterans do you think this would help?
Right now in the state of Maryland, probably about 375,000. Yeah.
And what's the fiscal note on something like that?
Statewide 4.1 mil, I think on the local 43.2.
Okay. Thank you.
Yeah, now to address that fiscal note, I was initially thinking about doing a carve out just for Vietnam veterans, but a disabled veteran is a disabled veteran, you know, so I you know, we all, you know, protected and served. So,
Yes, sir.
right, just to not acknowledge their contributions to this country as well.
Right. Thank you.
Sure.
All right, thank you, Delegate Brooks. Thank you, Delegate Barnes. Any other questions for Delegate Brooks? All right, thank you, Delegate Brooks. We do have
Okay, thanks, Chair.
one person signed up in favor and then one opposed. We'll start with Annette Garland. Ms. Garland, welcome to the Ways and Means Committee.
Hi, thank you. Good afternoon, Chair, Vice Chair, and members of the committee. Before I begin my testimony, I would like to thank Delegate Brooks for sponsoring my proposed legislation, House Bill 1175, a property tax credit for disabled veterans, and urge this committee to support the bill. I am the proud spouse of a disabled veteran and call Baltimore my home. My husband and I have been fortunate enough to purchase a home, and while researching veteran homeownership incentives, discovered that Maryland does not offer a property tax credit for disabled veterans that are not rated 100% disabled by the VA. According to the most recent available data from the VA, in 2019, there were a little over 90,000 disabled veterans residing in Maryland. Of the 90,000, only 15,000 were 100% disabled, leaving potentially 75,000 Maryland disabled veterans ineligible to receive a property tax credit for their primary residence. You may or may not know that a disabled veteran could have a service-connected disability that affects their ability to work or even perform simple daily living activities and still not be rated 100%. In fact, the average disability rating for disabled veterans is only 40%. It is no secret that disabled veterans face more challenges than the average population, including challenges financial in nature. Unfortunately, Maryland's consistently high property taxes serve as a deterrent for disabled veterans to remain here. There is no definitive data on disabled veterans leaving Maryland. However, in 2018, the VA projected that the state's overall veteran population would decrease by about 7,400 veterans. When the 2019 data became available, it revealed that in fact, Maryland's veteran population had decreased by nearly 28,000, 3 times the VA projection. There's no doubt that veterans are fleeing Maryland for more friendly tax states, including Texas and Florida, that offer property tax exemptions for all disabled veterans, regardless of disability rating. I urge a favorable report on the House Bill 1175. The passage of this bill will not only show Maryland's disabled veterans that the state values their service and contributions, but will also aid in making sure that the $3.4 billion of yearly VA expenditures spent in Maryland stays in Maryland. Thank you for your time, and I look forward to any questions.
Thank you, Ms. Garland, and thank you for your husband's service. Were there any questions for Ms. Garland? All right, thank you very much. Thank you for testifying today. We do have one more person signed up on this bill, Mr. Kevin Connelly from MACO.
Thank you, Madam Chair, and good afternoon to members of the committee. Kevin Connelly here on behalf of the Maryland Association of Counties in opposition to House Bill 1175. First, I had a really good conversation with a good delegate sponsoring this bill. I appreciate that talk. The issue that we have with the bill is that it's mandatory. It would require that counties grant this credit. If that's the case, it has a $43 million fiscal impact. We appreciate the tools to enact broad or targeted tax incentives at the local level, and we think this is best decided at the local level by the local governing body with proper community input. And in fact, last year we passed a bill out of this committee that gave counties a lot more flexibility when it comes to granting these types of credits for disabled veterans. And I think that flexibility would give them the option to do this bill. Delegate Brooks mentioned that Washington County does this, and I think it proves that counties want to provide these type of incentives, and they do, not just in form of property tax, but other incentives as well. So we would appreciate if the bill were enabling and it provided us with the flexibility to do this at the local level, but with a $43 million fiscal impact, it's not something that we can absorb. So we'd respectfully ask for an unfavorable report on House Bill 1175.
All right, thank you. Any questions for Mr. Connelly? All right, thank you both for testifying on this bill. Thank you, Delegate Brooks.
Yeah, Chair Kaiser, may I say one other thing?
Sure.
Sure, yeah. 1 month of the windfall from the Tax Cut Jobs Act could satisfy this fiscal note for a full year. Just wanted to put that out there.
All right, thank you.
Thank you.
All right, thank you all very much. We're done with the hearing on House Bill 1175. Moving on next to House Bill 1179 from the Wycomico County Delegation. Welcome, Delegate Anderson.
Thank you, Madam Chair. Committee members, family, it's good to see you all once again, even though it's virtually. I have before you a local bill, House Bill 1179, unanimously supported by the Wycomico delegation, signed by 6 members of the County Council, the acting county executive, endorsed by the Greater Salisbury Chamber of Commerce, the Greater Salisbury Committee, and the City of Salisbury. This bill would allow the county and or its municipalities to do an incentive package for residential development throughout the county. As you know, where we are located geographically, we're at an inherent disadvantage to Sussex County, Delaware, which has seen a historical housing boom. And as a result, our housing starts have slumbered almost to a stop and are now crawling around well below where they should be in a thriving housing market like we're seeing now. So this legislation is enabling. It would allow the county to enact any type of program to incentivize residential growth throughout the county. In essence, what an enterprise zone does for commercial property, something like this would do the same thing for residential. And so I think it's a brilliant idea to try to get us back on track. As you know, we're heavily dependent on the disparity grant, which we overrode the governor's veto this year. This would be a tool that would help us not have to rely on that by creating jobs in the housing and construction industry to get us back on track and competitive with our geographic neighbors, regardless of the state that they're in. And so again, this is a bill just for Wycomico County, supported by Wycomico County and for Wycomico County. So I ask you all for a favorable report, and thank you so very much for letting me hang out with y'all for a little bit.
Why, thank you so very much. We are, it was a pleasure. Any questions for Delegate Anderson? All right. Thank you, Delegate, very much. Thanks for
See y'all soon.
today. See you later. We next have House Bill 1180, Delegate Hill. I don't see her here. The 4 bills after that are from Delegate Conway. I don't see him as well. They are tracking them down. Delegate Feldmark, House Bill 1234.
Thank you, Madam Chair. Good afternoon, committee members. House Bill 1234, as the bill number suggests, is pretty straightforward. And this is dealing with the homeowner's property tax credit. The idea for this legislation grew out of the work that the local revenues subcommittee did with a briefing on tax sales over the interim. And as you may know, the homeowner's property tax credit is one of the strongest tools we have helping low-income homeowners avoid tax sale. And a lot of the really sad and tragic stories we hear are about folks who are eligible for the tax credit, but we're not receiving it. So what this bill aims to do is correct that and make sure that folks who have applied for the tax credit and continue to be eligible for it are automatically renewed. And to help make that work better, we're also adjusting the definition of income, that the income that is looked at and considered as part of qualifying for the tax credit, to make that match the Maryland adjusted gross income from the income taxes. So those are the 2 main changes. And the way we want to make sure this works is that if someone applies, they still have to apply initially to get the tax credit. But once they've received the tax credit, then based on information that SDAT and the Comptroller's Office already have, they can determine their continued eligibility. So there's no need to put the additional administrative burden on the credit recipient to continue to receive the credit. Now, I do want to point out a couple of points we're working on and discussing some possible amendments. You may have seen the letter of information from the Department of Assessment and Taxation. We do need to correct a couple of points around the timing of how this eligibility assessment and renewal would occur. The state already assesses continued eligibility, but rather than renewing the credit, they use that assessment of eligibility to notify recipients that they appear to be eligible and should apply again. So instead, instead of saying, hey, it looks like you're eligible for this, you need to do this additional paperwork to reapply, we'll say, hey, looks like you're eligible for this, we're renewing you. If any of this information that you previously submitted to us has changed, you need to let us know, okay? However, it follows the timeline that is in existing code with an August 1st notification. So we do need to move that timeline up to match the property tax billing cycle. So that's one change that we're working on. The other point I want to acknowledge is there is an unclear but estimated very large fiscal note on this. I think there's a few points that are perhaps overly aggressive in those estimates, but I also think we can work on making some adjustments to address the fiscal note. By changing the definition of income that's used to determine eligibility, we are potentially significantly broadening the universe of homeowners who would be eligible for the tax credit. So I think we can look at adjusting the thresholds to address that issue. And we need to do some additional work with SDAT and the Comptroller's Office to get a better sense of those numbers. But that's something we're looking at for a potential amendment to rein in potential concerns around the fiscal note. So that's a quick overview, and I know we've got a couple of folks here who can speak to sort of the frontline real life experience with this tax credit, but I'm happy to answer any questions you may have, and I ask for your favorable report.
Thank you, Delegate Feldmark. Any questions for Delegate Feldmark? All right, thank you, Delegate. We do have two people signed up on this bill, and then we'll go back to Delegate Hill's bill. We next have Louise Carwell. You're muted still.
My apologies. I hope that's better. Thank you to the chairperson and to members of the committee. My name is Louise Carwell. I am the senior attorney for consumer law at Maryland Legal Aid. Maryland Legal Aid encounters these issues in the cases where we advise or represent clients in foreclosure, in tax sale, and in other real property related cases. We also at Maryland Legal Aid represent individuals in family law matters and administrative law matters and landlord-tenant. This bill would so assist so many of our clients who are already receiving or eligible for the tax credit. We frequently encounter folks who come to our office who do not know they're eligible for the tax credit at all. And so we are able to help them apply and receive the homeowner's property tax credit. But it is in particular with I find in my cases elderly clients who just do not remember to reapply every year. And then they come to us or return to us because they either have a reverse mortgage and not paying your property taxes is a breach. And so they find themselves in a default under that mortgage or facing foreclosure under a reverse mortgage. Or if they have a mortgage that has an escrow account and they failed to receive the tax credit in a year, they then fall into a problem with the escrow and their mortgage payments increase tremendously. And we have to try to undo that if possible, or they face tax sale. And so we have to try to see if we can get a credit for them, or if we have to, unfortunately, file a Chapter 13 bankruptcy for them. So many times I have wished with cases I've handled, and I know many advocates here at Maryland Legal Aid wish the same thing, if there was a way to have an automatic renewal of that tax credit for these individuals who are very low income, for whom the tax credit really helps them retain their home ownership, what a benefit that would be. And so for that reason, Maryland Legal Aid urges that the committee give this a favorable report. I also want to say that the bill itself really supports efficiency in the process, efficiency with respect to the way that SDAT operates, and it does a wonderful job in administering this program for our clients. But also it gives efficiency to the fact that jurisdictions will automatically have that information.
Mrs. Carwell, Ms. Carwell, can you please wrap up?
Sure. Simply just, I do urge the committee to give this bill a favorable report. Thank you so much.
All right, thank you so much. Next, we have Amy Hennon signed up to testify.
Yes, thank you so much. Chair Kaiser and members of the committee, thank you so much for the opportunity to testify. My name is Amy Hennon. I am the Director of Advocacy and Financial Stabilization at the Maryland Volunteer Lawyer Service, and I really want to thank Delegate Feldmark for putting forth this really important bill. MVLS is the oldest and largest provider of pro bono legal services in the state of Maryland. Between clinics and full representation cases, we assist hundreds of clients every year in counties across the state that are facing tax sale. This tax credit is one of our strongest, our most powerful tool in helping folks save their homes. And it is always frustrating every time I come into contact with a client who previously had the homeowner's property tax credit and then didn't apply because they really missed out on both the funds to assist them in staying in their home, but also often the point that I come into contact with them, they are in a truly tragic sort of situation. And it is a real rush to try to get them credits as quickly as we can to hopefully get them out of tax sale. I was actually talking earlier today to my client, Helen, who we had gotten retroactive credits for previously up through 2019. And I was talking with her today because I thought we had gotten her enough supports in place so that she was going to be able to have her son help her apply for the credits every year. It didn't happen for 2020. And so I'm going to have to apply for retroactive credits for her again. She's eligible for them. But it's frustrating to me because I don't want hundreds of clients to be at risk of this, or thousands of clients to be at risk of this exact process every single year, because this process can be so onerous, especially for our older adult clients and our clients that are on incredibly low fixed incomes, who'd never see their income go up, who don't see a change in income. I do think that this bill would streamline the process considerably for SDAT, and I certainly understand that there is a large fiscal note attached to this bill, but I think that there are a variety of amendments that could be considered or that would lower that considerably. And I want to encourage the committee to think about the burden that we are placing, especially on our older adult residents in the state, and the importance of protecting them so that they can age in place and stay in their homes. They are pillars of their communities. The folks that we work with are so important to the communities that they live in. And so I want to urge a favorable report. And thank you so much for letting me testify.
Thank you both so much. Are there any questions for either testifying? Delegate Hartman.
So what safeguards thank you, Madam Chair, what safeguards would be in the bill to prevent if there's multiple generations living in the home and the home is in the name of the grandmother, or whatever, she passes on, what safeguards are in the bill to get it off of this automatic renewal so that the younger family members could pay the proper taxes or whatever?
So I'll take a stab at this. I believe that the notification from the comptroller's office would potentially notify that a person had passed away or that was no longer attached to the home, and that this would then potentially trigger that this property was no longer eligible or that a reapplication would be necessary.
So when someone dies, the comptroller notifies SDAT of that?
I think that it can be part of the process because the comptroller's office is notifying SDAT when people are eligible or potentially eligible.
Okay, so is that currently in the bill?
That is currently in the bill, and it's actually currently happening.
No, but as far as the notification of a death, is that something that is in the bill now, or could be added, you're saying?
I don't know that, I don't think it's specifically in the bill, but if I suspect that that's something that could be added if it needs to be specifically added.
Okay, thank you.
All right. Thank you, Delegate. Any other questions for people testifying on House Bill 1234? All right. Thank you both very much. Thank you for joining us today. We're done with the bill hearing on how many more times can I say House Bill 1234? Almost as fun as House Bill 711 of the Delegate D. Jones's. We will now go back to Delegate Hill's bill, House Bill 1180, and for Delegate Conway, who's here, your four bills all follow Delegate Hill. Delegate Hill, please go ahead.
Thank you very much, Madam Chairman, and good afternoon, Madam Chair, Mr. Vice Chair, and committee. I'm here to present 1180, which is enabling legislation that would lower from 75 decibels or LDN to 65, the threshold by which a local jurisdiction, primarily that would be Anne Arundel County, Howard County, and Baltimore County, may grant a airport noise contour tax credit to residential properties within that zone. And it would also allow the counties that choose to grant such a credit to do it in a tiered fashion. And essentially the zones, as described, the noise zones are drawn at 75 and 65 currently. The current tax credit is at 75. These zones have not been redrawn since 2008, but in 2015, the next gen flight paths were changed, and we're having many more residents who are dealing with air traffic noise. It is of note that the FAA considers any noise at the 65 level or higher to be significant and may even cause health risk of some significance. And so what we're trying to do is to help our constituents and those the surrounding counties who are affected by next gen to at least have the opportunity to ask for some redress from their local jurisdictions, but leaving it completely up to the local jurisdictions as to whether or not to grant it. And I think you'll note in your bill file support from MACO. Anne Arundel County comes in too with, I think, the executive against the bill as if it were a mandate. And then the other testimony suggests an amendment to give them the flexibility that I think they would already have. So with that, I will wait for questions and answers and ask for a favorable report. Thank you.
Thank you, Delegate Hill. Any questions for Delegate Hill? All right, thank you all very much. We do have one person signed up to testify, Kevin Connelly from MACO.
Good afternoon, Madam Chair, members of the committee. Kevin Connelly here on behalf of the Maryland Association of Counties in support with an amendment. I believe it's a friendly amendment to House Bill 1180. As I mentioned before, and as you all know, we appreciate the approach offered by House Bill 1180 as it provides counties with the flexibility and the autonomy to grant these tax incentives at the local level. Anne Arundel County already has this program. They have a tax credit for the 75th LDL. And all we're asking is that this bill not preempt their existing program, and that any change that would bring in more homeowners as being eligible for this credit, that change would be required to go through the county. So they would have to take action at the county level to implement this legislation, and it wouldn't automatically bring them in. So I know that this is sort of a technical and clarifying amendment. DLS does think that expenditures for the county would jump, I think, close to $800,000. So there's a little bit of question about whether or not this would automatically apply to them, to their current program. DLS thinks that it would. So we just asked for a clarifying amendment to say if this were to expand and bring in more homes as being eligible, that the county should have to modify its existing program at the local level, and it wouldn't be automatically preempting them. So we'd ask for a favorable report on House Bill 1180, and I'm with an amendment, and I'm happy to answer any questions.
All right, thank you. We do have a question. Start with Delegate Ebersol.
Thanks, Mr. Connelly. So the preemption you're talking about is preemption of who's eligible or at what level they're eligible, or both?
Right. So basically, because Anne Arundel already has this program and they already established it at the local level, we think that in order for them to expand this program, which would happen under this bill, they should have to take action locally. As the delegate mentioned, this is enabling legislation, and we just like to see it be truly enabling and not expand a tax credit that already exists, because if that were to happen, the county may have made a different decision on whether or not to do this based on the amount of revenue that they would have to give up. So it's really just saying, if they want to do this, they already have the program, make it truly enabling and let them have to take local action to expand the credit at the county level.
But what's creating the expansion? The change in the decibel level or the redrawing of the zones?
I think moving from the 75th to 65th would bring in more properties as being eligible. And so that would automatically mean that I think the fiscal note is about 800,000 for them in terms of the revenue loss. And again, that wasn't anticipated when they created this program and decided to move forward with it.
So just one more question, if I may, Madam Chair, to get it clear. So you're saying that by expanding that, they would then Anne Arundel County's program would automatically include those people, or could they choose to change that in such a way that they could do that if they didn't want to include them, or if they didn't want to offer them the tax break that was being offered before?
According to the way the bill is drafted, this bill would automatically increase eligibility for that current program without any local tax.
But eligibility, why would they automatically become part of the program then?
It's just because the bill basically expands the zone for the properties that are eligible for this. And so based on the amount of properties that would
Delegate Ebersol, wait, let him answer.
I'm sorry.
Based on the amount of properties that would now be eligible if this bill passes, it would automatically make those property owners eligible for this credit. And again, that's where we have the concern with the bill.
Okay, thank you.
Thank you. Any other questions for Mr. Connelly? All right, seeing none, thank you all very much. We are done with the hearing on House Bill 1180. Thank you, Delegate Hill. And we're now turned to Delegate Conway. And if we could take your 4 bills in order, Delegate Conway, let's start with House Bill 1217.
Thank you, Madam Chair. How are you doing today?
Thank you.
I'm Delegate Conway here to present, let's start with 1217. And what 1217 does is raises the tax sale threshold from $750 to $2,500. In the Baltimore City delegation meeting, we found out the average property tax is $1,250.
You're on.
And but we also found out that the city was opposing this bill because the city would lose revenue of what they said would be almost $6 million. The reason why is because the city sells your property tax in bundles to a company, and then the company has people purchasing parts of your property tax. So they have an outside other kind of scheme that's going on that's driving this property tax sale. And that's all I can tell you. I would still ask for a favorable because people are struggling right now, don't have their COVID money and waiting on stimulus checks. If we could help the people. But like I said, I'm just being upfront with you, the city is against this because they said they sent the letter to me that they oppose this because they would lose $6 million.
Thank you, Delegate. Has the city delegation taken a vote on this yet?
Yes, they voted no.
Oh.
They vote. That's why I was trying to tell you just straight. They voted no.
No, well, you told me that the mayor, that the city was against.
Oh, yes,
it.
yes.
The city delegation, have you all
City delegation, we voted on it. They voted no.
voted no? Yeah, you should maybe start with that too. Okay, all right. How about
All
your
right.
bill?
The next bill is 1219.
1219?
1219. So the 1219 is basically just to say that if your house comes up for a tax sale, that the city will send you a certified letter to say that your property is coming up for a tax sale. And we've had a lot of problems with the mail and mail delivery service. And the way this would work is that the city would send you that notice certified, and that certified notice fee would go on to your tax bill. So you would be liable for that, but we would be able to track the fact that you did receive notification. And with that, I'll be glad to answer any questions.
I'll first ask, has the city delegation voted on this one?
Yes, that was favorable.
Favorable, thank you. All right, any questions, any other questions for Delegate Conway? Delegate Barnes.
Thank you, Madam Chair. Delegate Conway, thank you for the bill. Roughly how many tax sales do you guys do a year?
I think they said like 4,000, 5,000, but like I said, what they do is they put it, just because they say it's a tax sale doesn't mean they're going to sell it. They put these 4,000 or 5,000 in a bundle, and a company buys the bundle. Then individuals can purchase like stock. They can purchase parts of the bundle like stock, and then when you repay it, they get part of that interest.
So, and then you would need to send a certified letter to all 4,000 or 5,000 of those individuals, correct?
Yes, yes.
And who covers that cost?
The property owner would cover that cost. That would be added onto your property tax.
Okay, but the city has to front that cost though, correct?
Yes.
Okay, thank you.
All right, thank you, Delegate.
Thank you.
Questions on House Bill 1219? All right, we'll move next to House Bill 1221. Delegate Conway.
Okay, 1221. Trying to get this together. Thank you, Madam Chair. Delegate Conway here to present House Bill 1221. And what House Bill 1221 basically said was that your house could not be brought up for the tax sale. It wouldn't be triggered by water and sewer charges. It would only be triggered by actual property tax values. And we found that some properties were being commingled with the property tax and the water bills to trigger off the tax sale. So what we want to do is say if the threshold is over the $750, which average tax on the property is $1,250, they wouldn't bundle the water bill in with the property tax to trigger the tax sale. But for the tax sale purposes, the water bill would be included once it was triggered. And I'll be glad to answer any questions if I can.
Delegate Conway, first question's always going to be, has the city delegation voted on this one?
They voted on it. They voted no.
They voted no.
Unfavorable.
All right, thank you. Delegate Conway, we have never before had bill hearings on bills killed by local delegations. A little unusual for us. Okay.
We have the listing here, and the names of the bills of my bills are incorrect. All kinds of stuff is happening. It's a new year.
Okay, all right. Thank you. House Bill 1222, Delegate Conway.
Okay, 1222. Well, I don't seem to have 12. Hold on just a second. Oh, it was a tax sales notice bill again. Wait a minute, I'm pulling it up. Okay. It seems like this might have been a duplicate or something, but what it says is on this one is where the Baltimore City, The notice required under subsection A of this section shall be sent by first-class certified mail. So this was also by the first-class certified mail. Bill drafted, we had problems. This one was favorable through the Baltimore City delegation. That's the 1222.
All right, thanks for answering my almost question. All right, thank you. Are there other questions for Delegate Conway on House Bill 1222? All right, thank you, Delegate Conway.
Thank you so very much.
We're done with the hearing on House Bill 1222. Is Delegate Amprey here for his bill? I don't see him yet. We will contact him. He's in a hearing in another committee right now, so we'll go now to another member with a property tax bill. Delegate Attar, House Bill 1246.
Thank you, Madam Chair, members. For the record, I'm Delegate Tara here presenting House Bill 1246, alteration to the leased vehicle excise tax. This bill is about affordability, safety, and the environment. When a person leases a vehicle, it's a brand new vehicle and they make monthly payments. This gives many people who may not be able to afford to purchase a brand new car the ability to drive a new, safe car. The current law in Maryland is you pay a 6% tax on the total purchase price of a leased vehicle. So say, for example, I, at the end of my lease term for my Jeep, pay a total of $17,000. I then return the vehicle to the dealership when the lease is done. When I go to lease the vehicle, I don't pay 6% on my cost on the $17,000. Rather, in Maryland, I pay 6% on the total purchase price, which let's say is around $25,000. In New York or a state like Illinois, I would be paying the tax on the $17,000 that I pay. This bill changes that. This bill, in complicated terms, alters the vehicle excise tax imposed on a lease vehicle by specifying the tax imposed is equal to 6% of the capitalized cost reduction in each monthly payment. In simpler terms, I would be paying 6% on $17,000, the price I paid to lease the vehicle, not 6% on $25,000, the price that I would have paid for the vehicle if I purchased it and got to keep it forever. Here are some reasons why this bill is necessary. First, safety. Newer vehicles have many safety features that are not in many older vehicles, including features to prevent accidents and features to reduce the impact of accidents. I can go on for quite a while about many different examples of how newer vehicles are safer, but I'll spare you the 30-minute testimony. On the topic of safety, the Maryland State Police provided me with their 2020 vehicle inspection statistics. In 2020, there were over 700,000 vehicles inspected, and 46% of those vehicles, almost 350,000, were rejected. And then when you look at that 46% number, I believe it coincides with why we have so many unregistered vehicles driving around. I'm going to leave the numbers regarding repair orders and unregistered vehicles in Baltimore City to the Baltimore Department to discuss, but it is extremely concerning that so many people are driving unregistered, thereby uninsured vehicles in our streets. And if it's unregistered, it will also not go through emissions testing. If a vehicle is leased, it has to be registered and insured. On another note, my day job is I'm a prosecutor, and that seems to tie into everything I do, even this. As I was thinking about this bill, I'm reminded how many times people are pulled over by the police simply because of the violations with the type of vehicle they are driving, generally older used vehicles. Affordability. Leasing prices change fairly often, but as of most recent, I was provided the following prices. With $0 down, it's $224 to lease a Hyundai Elantra in New York and $259 to lease it in Maryland, $264 to lease a Honda Civic in New York and $299 to lease it in Maryland. And again, these prices are both with no money down. Although to some of us, the difference in price being paid monthly seems minimal, to many people who would instead turn to a used and not as safe vehicle, this amount can make or break the decision to lease the vehicle. We want to ensure all individuals have access to safe vehicles. Building credit and having a sound financial future. Making monthly payments on a lease payment is a great way to build one's credit. We are living during times when one's credit makes a huge difference in how they will succeed financially. Having an option for low monthly payments is a great way of going about this and can change so many people's future. And the environment. I came from the E&T committee and learned so much about protecting our environment. Newer vehicles, by definition, are so much better for the health of our environment than many of the older vehicles being driven. I want to touch upon the fiscal notes. The fiscal note as written is extremely high. I believe the long-term benefits from this tax alteration greatly outweighs the current fiscal effect. However, my intention is still not to reduce such significant amounts of money from the transportation fund. I know the current importance of that fund as well. The way this bill is currently drafted, it includes commercial leased vehicles. That's not the intention of my bill, and I'm having continued discussions with MDOT about this. Most recently, they advised that excluding commercial vehicles will reduce the fiscal note by about $9.1 million. In addition to that, the fiscal note doesn't take into account the fact that leases typically have a shorter term than the average turnover of new cars, which means the fiscal note should be less. I'm also open to other ideas like putting a cap on the price of the vehicles eligible, a sunset on this in order for us to determine how much of a help this ends up being. And I look forward to working with this committee to amend this bill to ensure the intent of the bill is preserved while not significantly harming the transportation fund. I will now turn to my panel, but I want to point out that Joseph Attar is my brother. I asked him to come primarily to answer questions since he's an expert in much of what I discussed. I ask for a favorable report. Thank you.
Thank you, Delegate Attar. Can I ask two simpler questions? I just want to confirm, and this is more for the other members, that this bill is addressing long-term leases, so leases beyond 180 days. That's correct?
Absolutely.
And then in comparison to short-term leases, which are often people from out of state, though occasionally those of us in state as well, after a car accident or cars in the shop for a while. Are these long-term leases generally more likely to be state residents? Is that your belief?
So my understanding, I got numbers from the MDOT, the MVA, to tell me how many people lease vehicles. And my understanding, those were Maryland, people that registered their vehicles in Maryland, or else I don't think the MVA would have it. And we're looking at a little over 38,000 for non-commercial vehicles and 8,400 for commercial vehicles. And so I believe those are all Maryland residents.
All right. Well, thank you for that, because I want to, I mean, sometimes the argument is it's okay to tax the people from the other states, but this bill is about an unfair tax on Marylanders. Okay.
Thank you.
Thank you. Any other questions for the delegate? We will next go to Franz Schneiderman.
Thank you, Chair Kaiser, Delegate Attar, and members of the committee. Thanks for the opportunity to address this bill. My name is Franz Schneiderman. I'm Executive Director of Consumer Auto Maryland. We're a nonprofit group that works for safety, fairness, and transparency for Maryland drivers and car buyers. We were happy to support HB 1249. We think it's an innovative idea and just a fairer way to tax leased vehicles and a way to make quality vehicles more affordable for some Maryland families at a time when that's really important and when the cost of owning a vehicle is really accelerating in ways that are a problem for a lot of people. Right now, if you lease a car for more than 180 days, you pay 6% tax on the whole purchase price of the vehicle, as if you owned, say, a $30,000 vehicle. But of course, you don't actually own such an asset. You're leasing it for a period of perhaps 2-3 years. So, it seems excessive and unfair to tax you as if you had purchased that whole vehicle, when really what you're doing is consuming, maybe $8,000 to $10,000 of the value of the vehicle on a 3-year lease. So it's fairer to tax the amount of the vehicle's value that you're consuming and your payments, I think. It also would tend to make leases more affordable. Figures I discussed with Delegate Attar suggested the same vehicle rented in New York State, which does the tax the way this bill proposes, would cost $30 to $35 less a month for a Maryland family. That's not a fortune, but it would mean $350 to $400 in savings a year for a low to middle income family. That could make a significant difference. I just want to stress too that this problem is really growing in terms of the affordability of cars. In the pandemic, the cost of both new cars and used cars has exploded. The average cost of a new car now is more than $40,000. The average cost of a used car has also gone up about 14% in the last year, so that even the average price of a used car is more than $23,000. So that isn't even necessarily an affordable option for middle income families. Also, of course, auto insurance costs on average more than $1,800 a year. And if you live in certain neighborhoods or you have poor credit or other problems, it can be necessary to pay $2,500 to $3,000 or more just for car insurance to be on the road. So this is a way to make access to an affordable vehicle somewhat more quality vehicle, somewhat more affordable for Maryland families. Could be a real, and that's very important to mobility and economic opportunity, and it's important in this time when a lot of families are hard pressed. So support the bill, ask you to give it a favorable report. Thank you.
All right, thank you so much, Mr. Schneiderman. The second person I'm calling up is Mr. Joseph Attar, but I'm going to suggest, as Delegate Attar pointed out, that this is her brother, that this bill's passage would be a lot better, sir, if you're able to send us some pictures of your sister when she was 6 years old doing something embarrassing. So please send that along to the committee and we'll share that with everyone. Welcome today, and thank you for testifying.
Thank you, Madam Chair, members. So I am Joseph Attar, Delegate Attar's favorite brother, I think. Full disclosure, I am in the auto business. I'm a partner in a used car dealership and in auto repair facilities. I do not lease vehicles to customers. The only benefit I may have from this bill is my wife leases her vehicles, so the tax alteration will affect me. But I am fortunate, as is my sister, to be in a position that regardless of this bill passing, I will be continued leasing vehicles for my wife. In fact, this bill may actually hurt my business by causing customers to turn to leasing vehicles instead of purchasing used vehicles. But I understand the intent of the bill, and I agree in the big picture it could help many people, which is why I agree.
I think we've lost your audio for a moment. You muted, sir. Mr. Attar, you have muted. Can you fix your screen? You've muted your computer.
Much less to lease a vehicle, which in turn makes leasing new vehicles more affordable. You can also lease vehicles with little to no money down, again making it affordable. It's very difficult to purchase a used vehicle with no money down and have a payment of less than $250 a month because the interest rates on a used vehicle is higher than a new vehicle. Further, not having to worry about maintenance costs, which could easily be $1,500. Hello? Can you hear me?
We can.
Oh, sorry. Further, not having to worry about maintenance costs, which could easily be $1,500 to $2,000 a year, makes it that much more affordable. On a daily basis, I see the issues in our city and in general with used vehicles versus new. People purchase used vehicles and don't have the funds to register or pay for repairs needed to safety inspect the vehicle to put it on the road. In turn, they drive the vehicle unregistered and uninsured with temporary tags easily accessible on the internet, which are illegal. The safety features that new vehicles have is unparalleled to what some of the older used vehicles on the street are equipped with. As Dahlia mentioned, the emissions of a new vehicle versus an old vehicle produce a much cleaner environment. Too often, I witness the heartbreaking event of someone's older used vehicle needing repairs and they cannot afford the repairs. The vehicle will sit in the auto service facility, and this person will have and this person will not have the means to commute to work or get around and can ultimately lose their job. I personally witnessed someone having to give up funds to be used for food shopping for their family to repair their vehicle instead. A new lease vehicle is under warranty for the duration of the lease, and these repair costs will not occur. I can't think of one benefit a used purchase has over a lease of a new vehicle for most people making a lower to mid income. I can talk for a while about all the benefits this bill will have, and especially for lower income citizens of the city, but I know my time is limited, so I'll stop.
All right. Thank you. We'll wait for questions after we have 3 more people, and there'll be questions opened up. We next have Mr. Sherri Small.
Hello?
Hello, we can hear you.
Hello? Hello? Hello?
Yep. Sorry about that. Let me adjust a little bit. Well, good afternoon, everyone. Madam Chairperson, delegates. I thank you for this opportunity to come and speak. My name is Sherri Small. I have a tax accounting and financial planning practice here in Baltimore called SGS Financial Firm. My time that I wanted to speak on is, of course, is the HB 1246 exercise tax on lease vehicles. The reason why I want to support this bill is, me being a financial planner, I sit down with people every single day. I go over their finances. I'm going to go over their budget. And I have a good amount of clients that want more in leasing a vehicle as opposed to buying a vehicle. Number one is easier, is one of the best ways to start building credit that people wind up making that decision. Also, it fits the budget to make it more affordable. Living in Baltimore, unfortunately, we have a lot of poverty that goes on within, the city of Baltimore. So a lot of our residents are living, paycheck to paycheck. So that's one of the reasons why people want leasing a vehicle as opposed to buying a vehicle. Another reason why is, leasing a vehicle is you want to get a new model. So you want to get a new vehicle. So they want to need more reliable transportation. The reason why more people want leasing a vehicle as opposed to buying the vehicle. People trying to get to point A to point B, people trying to get to work, trying to pick up their kids. They don't want to be on the side with, a vehicle not working. But the issue that we see right now is that the vehicles that are being leased, they're taxed on the full use of it as opposed to the use of the lease, average of the years of the lease of a vehicle. The average years of a lease of a vehicle is around 3 years. But they getting taxed on the vehicle for like 6-7 years of owning the vehicle, and that's not right. So Sharon should be taxed on the use of the vehicle, which is around 2 or 3 years. That's the average years of a lease of a vehicle. So that's why I'm supportive of this bill because that's going to keep more money in residents and my clients' pocket, and they can use that money for to be able to take care of their kids, to meet the standard of living expenses. So I'm very supportive of this bill. I think it will be very helpful especially for residents all over the state of Maryland, but in particular with the residents that I serve in the city of, city of Baltimore. So, I'm thankful for this, opportunity to speak, and I hope that you will be, in favor of this bill.
Thank you very much. Thank you for your testimony. We next have Michelle Wurzberger.
Good afternoon, Chair Kaiser, Vice Chair Washington, members of the committee. Thank you for allowing me to testify in support of this bill. My name is Michelle Wurzberger, for the record, and I am the Director of Government Affairs for the Baltimore Police Department. I don't have any pictures of Delegate Attar that are fun that I could share. I will be brief. I know you all have our bill report, but I just want to highlight a couple of things issues that we raised. And essentially, we are supporting this bill because we believe that it is one tool, one thing that could help get some unsafe and unregistered vehicles off the road by making it cheaper for individuals to lease vehicles. As you probably know, you may have experienced this yourself. Law enforcement officers are trained to stop drivers who are operating vehicles that appear to be unsafe because they have inoperable tail lights or headlights or rear view mirrors or the like. Those officers oftentimes will provide the driver with a citation and an established amount of time to repair the damaged or non-functioning part of the vehicle in order to protect the driver and every other driver on the road. In 2019, the BPD issued in excess of 8,400 such repair orders and warnings. Officers are also required to ensure that the vehicles that they encounter, whether they're driving past them or they've stopped them for some other reason, that they're properly registered and that they appropriately display that registration. This is done for a variety of reasons, but also to ensure that the vehicles have been properly inspected and certified to be safe. In 2019, the Baltimore Police Department issued in excess of 11,000 citations and warnings to drivers with canceled, expired, or suspended registrations. What we found, and you've heard from other folks on this panel, that many times individuals, will continue to drive a car that is unsafe because they can't afford to make the repair. They can't afford to make the repairs to then get it registered. And we think this is just one more option to help safeguard those drivers and other drivers. And for that reason, we request a favorable report. Thank you.
Thank you so much. And we have one more person signed up. We have Peter Kitzmiller.
Madam Chair, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchise new car and truck dealers from across the state of Maryland. I first want to thank Delegate Attar. She made a number of excellent points about the benefits of leasing. We signed up favorable on this bill before we were able to see the fiscal note. We are always supportive of anything that makes it more affordable for our customers to lease or buy vehicles. And there is no question that new cars and trucks are becoming more and more expensive. Having said that, we also realize the difficult budget situation that this committee in the state of Maryland is dealing with, and that a $50 million decrease in revenue is probably unrealistic at this point. But I do want to make one point that hasn't been made today, and that is the impact of leasing on electric vehicles. Maryland, along with 9 other Northeast states and the state of California, has made specific commitments about dramatically increasing the number of electric vehicles on the road in the state of Maryland. And we hover right now about 2.5% of the market in Maryland is electric or plug-in hybrid vehicles. I think this is going to be the year that you're going to see some pretty significant increases in those numbers. And that's because consumers are going to be able to choose from electric pickups on down. Before, they've been limited to very small cars, things people really didn't want to buy, but we're going to see electric cars across the market. And one of the things that I think is going to be critical to increasing the number of electric cars is leasing. As people have mentioned, leasing allows you to get into a vehicle for less money up front. It's a little bit cheaper. But in addition to that, there are some people that are not sure about electric cars. I want to try one, but do I want to buy one? And then if I don't like it, I'm stuck with it. Well, if you lease the vehicle, that concern's not there. You lease the vehicle for your 3-year term or whatever it is. And if you don't like an electric vehicle or it doesn't fit your lifestyle, you simply walk away and you don't have to worry about disposing the vehicle. So I do think that we should take a look at maybe tweaking how we tax leases in Maryland. Some of these other states have been mentioned. Obviously, the price tag on this method seems to be significantly higher than I actually thought it was going to be. But I think there's some things we can look at, and we certainly plan, as our association plans, to look at that, maybe somehow taxing it on the monthly payment and spreading it out more. But I think leasing does have a benefit. I think it is going to be an integral part of these electric cars on the road moving forward. But we are also realistic about the fiscal note. Thank you.
Thank you, Mr. Kitzmiller. Are there any questions for anyone on this panel? Delegate Ebersole.
And I'm sorry, Madam Chair, this might be for the sponsor, but we'll see. You talked about reducing the fiscal note by saying that didn't apply to commercial vehicles. I want to be sure I understand what we were talking about when we talk about commercial vehicles. And I also missed the number you thought you could reduce it by.
Okay, sure, thanks. So commercial vehicles are generally vehicles that are leased through a company. A lot of companies have vehicles for their employees that they use, whether it's to transport stuff or personal vehicles for their employees that the company pays. And MBA provided me with, there's 8,400 commercial leases, which will reduce the fiscal note by about $9.1 million.
Thank you. I missed the figure and I appreciate you repeating.
Sure.
All right, thank you. Any other questions for the delegate or for her panel? All right, thank you all very much. Thank you for testifying today. We are done with the hearing on House Bill 1246. We have 2 more tax bills to deal with, and we'll go to Delegate Ivey, House Bill 1255.
Thank you, Madam Chair. Colleagues, for the record, Delegate Julian Ivey here presenting House Bill 1255. House Bill 1255 aims to promote, facilitate, and expand participation in the homeowners and homestead property tax credit programs. This legislation would require SDAT to design a 1-page document about the homestead property tax credit, which is to be included as an addendum to a contract at the point of sale of owner-occupied residential property. The document must include the following statement. If you live in this home as your principal residence, you may qualify for the homestead property tax credit. The homestead property tax credit may significantly reduce the amount of property taxes you owe, end quote. This document must include instructions on applying for the tax credit online, and it must also include a complete paper application with instructions on how to submit it to the department. SDAT must make the document available on its website where it may be easily accessed by real estate brokers or other parties. This legislation also reduces the age from 70 to 60 years old for individuals who otherwise qualify to be able to apply for the tax credits retroactively. House Bill 1255, as introduced, alters the definition of gross income similarly to Delegate Feldmark's House Bill 1234. However, I've submitted an amendment striking that language, which significantly reduces the fiscal note. I look forward to working with Delegate Feldmark on her legislation. Lastly, House Bill 1255 required SDAT to contract the usability consultant to review all the public informational materials and forms produced by the department concerning the homestead and homeowners tax credits by August 1st of this year. By December 1st, 2021, the consultant must make recommendations to SDAT on how to make the department's materials on these property tax credits more usable. As a committee, we're well aware of the challenges faced by homeowners in accessing property tax credit programs. We're also aware of the tax sale foreclosures that are impacting our state's vulnerable low-income homeowners. We must ensure that homeowners who qualify for these programs are aware of them and are fully equipped with the information needed to apply. These vulnerable homeowners had access to these tax credits. They might not lose their home due to tax liens. Older homeowners are disproportionately represented in tax sales, and by the time they enter the process have already accumulated years of unpaid tax debts, which is why it's important for us to lower the age which they would be able to apply retroactively. We already know the tools in place to help solve the debt crisis for these homeowners. House Bill 1255 aims to ensure that SDAT is using these tools effectively to promote and facilitate participation in these most crucial property tax credit programs. We'll hear from several stakeholders supporting this legislation with some amendments, and I look forward to working with them on this piece of legislation. And I'm asking for a favorable report on House Bill 1255. Thank you, Madam Chair.
Thank you, Delegate. Any questions for Delegate Ivy on this bill?
I'd also like to thank Stan for all his work helping craft this legislation.
He is the man. All right. All right, yes, with credit to Delegate Barnes on that one. All right. Any questions for Delegate Ivy? All right, thank you, Delegate. We do have 2 people signed up. We'll start with Susan Mitchell, favorable with amendment.
Yes, good afternoon, Madam Chair, members of the committee. Susan Mitchell here on behalf of the Maryland Realtors. We do support HB 1255 with amendments. Given the significant increases in assessments over the past couple of years, on average about 8% throughout the state, a lot of the property owners throughout the state are using the homestead property tax credit. We support the educational outreach efforts to the homeowners about the tax credit. Basically, the first amendment that we do address is it clarifies the disclosure language about the credit so that it's included in the actual residential contract language. Right now in paragraph 55 of the residential contract, there is already a property tax paragraph with regard to property tax assessment and notice. This would be a good place to put that paragraph that gives the suggested language versus a long addendum. As many of you know from purchasing homes, some of these contracts get up to 48 pages long. Another addendum we believe some of the purchasers aren't really going to see. We think if it's right there up front in the contract with a link to DSAT and the homestead property tax language, it benefits everybody overall. The second amendment deals with, instead of a mandated statement from DSAT at settlement from title companies, this should be something the title companies can give the new purchasers the statement indicating this is the information where they can get it. Sometimes from purchasing a home to settlement, it can be up to 50 days. So they might see the contract 50 days earlier and then they're seeing settlement docs. And we think just the reminder for a title company to offer that is probably the better vehicle. With these amendments, we urge a favorable report. Thank you.
Thank you so much. And then we also have Kevin Connelly.
Thank you, Madam Chair, members of the committee. Kevin Connelly here in support with an amendment to House Bill 1255. You have my written testimony. I'd like to just make a few points. Number one, we think that the idea of STAT providing this one pager to be included in as an addendum for contracts is a great idea. We want to make sure people understand the opportunities that are available to them when it comes to the homeowners or homestead property tax credit. No issue there. The one piece of the bill that we do have a concern with is that several counties already grant a supplement to the homeowners property tax credit program, and the cost of that is completely borne by the local governments. And by altering the computation and the eligibility of this program, the local programs may be affected. And again, this is another issue where, like before, those jurisdictions may not have implemented this program or may have changed the local supplement based on, if they would have known that this bill would have been passed, which would potentially cost them a lot more money at the local level. So again, we have no issue with this bill in terms of providing taxpayers with the information they need to take advantage of these credits. However, we'd like to try and make sure that we don't affect the local supplements as a result of this bill making more folks eligible or changing their income eligibility. So again, we think it's a very good bill. And with this amendment, we'd ask for a favorable report on House Bill 1255.
Thank you both very much. Thanks for working along with the sponsor on these amendments. Any questions for either Ms. Mitchell or Mr. Connelly? All right, thank you both very much. Thank you, Delegate Ivy. We are done with the hearing on House Bill 1255. We've not yet been joined by Delegate Amprey, so we will break from taxes to election law and come back to Delegate Amprey later. Now moving on to the 5 election law bills on our agenda. Delegate Cox, House Bill 1145.
Good afternoon, Madam Chair and members of the committee. It's an honor to come before you today with House Bill 1145, election law absentee ballots request and signature verification. This bill is a simple trust but verify confidence builder in our absentee ballot process. As the committee is well aware, the opportunities for voting by mail have greatly expanded and is likely to continue to expand pending this committee and other bills that are before the legislature. This bill has 2 components. First, the process to provide more verification for the identity of the voter would require a real ID compliant issued driver's license, a proof of residency in Maryland, and an affidavit signed by the voter that they are a United States citizen. And second, a process for verifying those signatures. Now, one of the criticisms has historically been, and again, I think is in the record from the Attorney General and a couple other sources, that this could potentially disenfranchise voters. And I want to emphasize that the intent of the bill was not to do any such of a thing. In particular, I wrote in the opportunity to provide a free ID. I know the fiscal note indicated that that could be a loss of revenue, but when you compare that to the opportunity to make sure that we don't disenfranchise any potential voter, I think that that will pay for itself in terms of voter confidence and access to the ballot. Secondly, when you look at the process for voting right now in Maryland, if anyone shows up and can't produce an ID, they're already permitted to vote provisionally. So there would be no disenfranchising. The process for verifying that person could come later through the provisional ballot review process. This bill also provides in the verification process, taking away from the circuit court any challenge, so that it's not, you're not taking a political issue up to the courts, rather puts it before the local elected body of the county. That provision is modeled after the state of Pennsylvania and my personal experience of seeing how that works. It's, I think, a rather practical approach. It does allow for immediate review by the elected officials in the county rather than mixing it up with the judiciary. And then finally, the Attorney General's opinion that he put in was, I think, illustrative and indicated that there is evidence in the voter record and voter files that there are voters that do not have signatures on file. So the intent of the bill is to address that issue and ultimately to provide a mechanism a little bit clearer in the law that will allow our state to just simply comply with what the law is. This isn't really anything new. Or, there's some testimony that this, I think Marylanders Against Poverty had some concerns that it was unnecessary and that verifying voters is not needed. Well, the law already mandates verification. This just cleans that up and makes it more, I think, democratic, because if we can't verify who the voters are, then I think that disenfranchises every lawful voter. So for that, I would urge a favorable, and I thank you for your time.
Thank you, Delegate. Questions? Delegate Wilkins.
I did have I don't know if he's in the, I did have a witness. I don't know if he's in the,
Delegate
Mr. Lewis
Cox.
Porter.
Delegate Cox. There's a question for you from Delegate Wilkins. We get the witnesses next. Thank you. Delegate Wilkins.
Thank you.
Okay, thank you, Madam Chair.
Thank you, Madam Chair, and hi, Delegate Cox. Good to see you. I had a couple of questions.
Hello, Delegate.
Hello. Had a couple of questions for you on this. I wanted to know if you saw the Attorney General's comment that there weren't any complaints in terms of impersonation via the absentee ballot.
Yes, I did notice that he made a statement that the complaints were not widespread. I don't know that he said there weren't any complaints. I could have misread that, but I did see that, yes.
Yes, it does say that we did not see any complaints. So I wanted to make sure, I wanted to point that out, make sure you saw it. And I also was wondering if your bill will apply to military voters. A lot of military voters do use the absentee ballot, and it seems like having to provide a driver's license that complies with the Real ID Act, proof of residency, and an affidavit might be a lot for our overseas folks. So I was just wondering if it applied to them or not.
That's an excellent question. My understanding is that it's an or exception in the law. When I pulled the statute, it looks like there already exists a mechanism for military voters. That's my understanding. That was the intent. Let me see if I have that here in front of me. I did read that, and it should be a separate process for military voters in the statute. That's my best answer on that.
They do apply by absentee ballot as well, Delegate. Just finishing up.
Absolutely.
I wanted to play out for you. So I'm someone, Delegate, who has pretty bad handwriting as a lefty, and a pretty bad signature that's illegible, and I tend to sign in different ways on different documents. So I wanted to walk through with you in terms of the verification, how that would work. Would I have an opportunity, if my ballot was rejected under your bill, is there an opportunity to cure that in the sense of the Department of Elections, local or state, to contact me and say, hey, we're not really sure, you signed a couple of different ways in terms of being able to verify, so that I could just kind of clean that up easily?
So the intent of the language that I submitted was not to address things that already exist. I believe there already is a mechanism in the law for curing. I did not seek to change that. Now, if it comes with some clarity that there is not already a mechanism for that, I would certainly want to amend it to allow for any curing and have, make sure that there's particular rules with it. I know one of the issues with curing is to make sure there's rules that we can all abide by prior to elections that are clear and that don't indefinitely or in a lengthy manner extend the process so that you have an election that kind of drags out for a couple of weeks of curing. So that would be the only thought I had, but I do believe that the intent of the bill was to keep the law as it is right now regarding curing.
We don't have curing currently required in our law. So I'm just concerned that with the absence of that opportunity for the voter to correct that action, that might be a challenge given all the verification mechanisms in your bill. But thank you so much for answering those questions.
All right, thank you. Delegate Lutke.
Thank you.
Thank you, Madam Chair. Thank you, Delegate. First of all, I'd like to follow up on Delegate Wilkins' earlier question. Many of our military and overseas voters request absentee ballots, but they don't use the Maryland form. They use something called the Federal Postcard Application, which is a standardized absentee ballot request form that's recognized by all 50 states. And the reason for that is because it's easier for the military to get their service members overseas to have the opportunity to vote if they don't have to distribute 50 different absentee ballot applications. The way your bill is written, it would basically make it so that Maryland would no longer accept the federal postcard application because the federal postcard application has no process for verifying using these documents that you propose here. So is it your intention to disenfranchise these military voters?
Well, of course not. Thank you, Mr. Majority Leader. It's good to see you. And no, the intent is strictly to address the process of application from a straightforward approach that the statute would equally apply without disenfranchising anyone. And I know that in the fiscal note, it identifies the process presently includes a verification process of the Maryland driver's license and social security number. So this would be similar, just simply improving that with a verification of residency. And then the Uniform Services Voter Act is already incorporated in the statute. So my understanding is that that would not change, but certainly would want to make sure, and I didn't see any statement in the fiscal note that that would be impacted, but if it would be in any way, based upon your concern, I would want to make sure that we would address that for sure.
All right. The other question I had about those bills, the bill requires the use of a real ID, compliant ID. And as you may know, there are a lot of folks that for various reasons have not gotten a real ID. And the largest is that they're concerned about sharing the personal documents that are necessary to get a real ID with the government. And these are particularly folks on the sort of conservative end of the spectrum. So is it, I mean, essentially the bill would say that if you don't have a real ID, if you're one of these US citizens, you're an eligible voter, but you don't have a real ID, you would not be allowed to get an absentee ballot anymore?
Well, thank you for the question. As I think we are aware, the current statute requires the Maryland driver's license, and so under the federal law, Maryland driver's licenses now must comply with the Real ID Act. So there really isn't a change there. The real change is the residency, in my opinion, in terms of the intent of the bill. And certainly, I think that when you look at the greatly increased numbers of mail-in ballot applications, there is no process presently to verify residency other than a driver's license. And so I think that would be the intent, to make sure that the process that exists already would be secure. I think the way that it looks now, and I'm certain that the Elections Board would have more information about the process, but right now they're already required in an absentee mail-in ballot to provide a driver's license and social security number. So that's a secure process. It's not a process, I think, that is released. I think it's not, I don't believe it's held in the database either, but I could be wrong on that. So the intent is not to expand any data collection, if that's your question.
All right, thank you, Delegate Cox. Seeing no
Thank
other, we'll move on to those signed up to testify. We have Lewis Porter. Mr. Porter, are you here? Please unmute. Mr. Porter.
Can you hear me?
Now we can, yes, you're.
Okay. I also have a camera on if you want to turn that on too, but if you're not.
That's not for us to turn on. It doesn't, from our end, it looks like your camera's off, but go ahead, please.
Okay, well, very good. Okay, I'm Lewis Porter. I'm founder of the Maryland 2020 Watch. It's a group non-affiliated with any political party. We've been tracking Maryland's elections now for over 10 years. I want you to know I strongly support Delegate Cox's bill, HB 1145. Because of these investigations that we've done, I've testified before the Annapolis Board of Elections and there in Annapolis at the government, and on a number of matters that have that are issues that have weakened the citizens' viewpoint and protections for having the elections being done in a way that opens it up to where there's no verification or that who people are saying that they are say. I have seen and we've testified and witnessed to those actions, and I have it in writing in different places that we've spoken on. So any bill that would help the citizens have more confidence in the election would certainly go a long ways to the citizens' concerns about what's going on in a given election, especially having witnessed this last 2020 election. That was a travesty. So providing identification it's time honored, and it's also in the law to do that. And this concern about the integrity of the election process is actually put right at the top of what the Board of Elections goal is to have the citizens know that the elections are fair and honest, and that who people say that they are those people that are voting. So for every person gets a vote, and that person is the person that they say they are. So anyway, to that end, again, we strongly support this bill and building any integrity back into the system that can be put into the system. From Maryland 2020 Watch's point of view, that would be very much appreciated. And I thank you very much for giving me the opportunity to speak on this matter. Thank you.
Thank you, Mr. Porter. Before I call on Ms. Minnecki, I will point out that not a single election official, GOP or Democrat or any Secretary of State found any widespread election fraud this past election. So I just want to add that to the hearing right now. Ms. Minnecki, please go ahead.
Thank you, Madam Chairman, members of the committee. The National Federation of the Blind of Maryland opposes this bill because we feel that it will increase discrimination against people with disabilities. Now, as blind people can sign documents, but we rarely do it the same way all the time. And that is just the nature of blindness, okay? So it's not anybody's fault that our signature would have to be verified. We'd have to go to the board every election. And so that will increase discrimination, because the more you have to go, the more chances you could be disenfranchised. And it's not true of just the blind. There are other people with disabilities who have various difficulties, and their signature would be difficult to verify. Plus, as we all age, our vision declines naturally. And so this is also discriminatory against the elderly, because you sign your voting record and then you might be voting for years and years and years. And so when it would be compared, then you'd be out of luck. The other thing that I wanted to mention is that when you get your real ID card or your ID driver's license, whatever the case may be, you have to produce a proof of residence. So we believe that it's redundant to make you do your proof of residence again, because you wouldn't get the card if you didn't have proof of residence. And so that's another example of this bill is a burden, and it will deny access to voting for people. And that's why we urge an unfavorable position. Thank you.
Thank you, Ms. Minneke. Are there any questions for either of the witnesses on this bill? I should have taken a break between both favorable and unfavorable. Any questions from any members? All right. Thank you both very much. We're then done with the hearing on House Bill 1145. We're going to go to 1165 and then to Delegate Amprey's bill. Delegate Cox, House Bill 1165.
Thank you again, Madam Chair, and I'm honored the committee to come forward and present House Bill 1165. Again, Delegate Cox, for the record, manual post-election tabulation audit timing in effect. And I want to start out by just saying that I concur with Madam Chair's position. There's more to our democracy than free and fair elections. Ultimately, we must take steps to ensure that people have the utmost confidence in our elections. As you had said then, I fully support and agree with that, because that is really, I think, helpful to all persons that we have that level of confidence. This bill is simple. It just moves the date for the manual audit from after the certification. It says currently 120 days after the general election, but I'm moving it. I would like to move it before the certification. This is something that has been bipartisan. It is common sense. It's a measure that provides immediate confidence prior to certification of the winner of any election, and it's a minor change. It is something that can be worked out very easily. It's already law. It's just when you have to get it done. There is some question in some of the testimony. I think it might have been the Attorney General, I'm drawing a blank, that there might not be enough time presently for doing the manual audit before certification. And I think that that can be remedied by a simple amendment. I'm happy to work with the committee on that. This is an important process to manually tabulate the ballots. Now, presently, under Maryland law, the election does not have any kind of verification beyond the software audit. So you're looking at simply copies in the system that are duplicates, and you're verifying something that's basically in a closed system in a circle. You're not actually laying hold of the actual ballot to do the audit, and that's something verification of the paper ballots is necessary. Presently, the law requires a 1% for mail-in ballots verification sampling and 2% for election day. So I think that this is a common sense approach. I think it's something that, like I said, has been bipartisan, and I think that the committee would probably find a lot of support across the aisle, particularly with some of the professionals, as in the record, Professor Borvi Vora of George Washington University put in support for this procedure, and her past support for your bill, Madam Chair, as well as Lynn Garland has written and co-authored similar best practices as president of verifiedvoting.org that would reflect this manual audit prior to certification of an election. So with that, I would urge that the committee provide favorable on House Bill 1165. Thank you.
Thank you, Delegate. Any questions for Delegate Cox on this bill? All right. Thank you, Delegate Cox. Yes, we're in agreement about the pre-certification. I have a different kind of audit, so you can take a look at my bill as well. But seeing no other questions and no one is signed up on 1165, thank you, Delegate. We're done with the hearing on 1165. We'll go back to Delegate Amprey's bill.
Thank you.
1289. All right, Delegate Amprey, go ahead. All right, the delegate is here, but not speaking. We have 4 more bills. Delegate Washington, House Bill 1249.
Thank you, Madam Chair, and Madam Speaker, as I most times say on here. Thank you, Madam Chair. Nice to see everybody in this committee. Great to be here instead of in ECM where I was for about 2 hours. Alonzo Washington, for the record, here to present on House Bill 1249. First, this bill requires that all members of the State Board of Elections have extensive knowledge of the Maryland's election laws and at least 5 years of experience in administrating elections. Second, the bill targets racial disparities that exist within our election systems, and by creating a position of a racial equity coordinator through the state board, through an appointment through the state board. The other piece in here was one that's really critical in here, which is it overhauls the appointment process for local boards of elections. In Maryland, members of local boards of elections are appointed by the governor, which creates an unfair partisan advantage to whomever holds the governor's office. This bill would shift the governor's power to appoint and remove members of the local boards of elections to local jurisdictions. This is an important step to ensuring that our elections officials' powers are derived from the people they serve directly. Additionally, the boards of elections, just so some of you know, the boards of elections in Prince George's County, Baltimore City, and Montgomery County, which are overwhelmingly vote Democratic, are led by Republican members appointed by our Republican governor. At some point in the future, when there is a Democrat that fills the governorship, boards of elections in Maryland rural counties that vote overwhelmingly Republican may be led by Democrats, and they have in the past. Neither of these scenarios are representative of the voters in these boards that they serve. And I ask for a favorable report on this bill. I'd be happy to take any questions, Madam Chair.
Any questions for Delegate Washington on this bill? Thank you. Seeing no questions, we'll move on to Joanne Antoine from Common Cause.
Yes, good afternoon, Chair Kaiser, members of the committee. For the record, my name is Joanne Antoine, Executive Director of Common Cause Maryland, testifying in support of House Bill 1249, which would establish the position of Racial Equity Coordinator within the State Board of Elections. I do also just want to note that we are only testifying in support of the creation of the position. We're taking no position on the other aspects of the bill that address the actual membership of the board. As an organization, we, recognize the long-standing history of the racially discriminatory and oppressive laws that have led to limited access to voting, and that these laws have overwhelmingly been targeted at Black and Brown voters. We see that happening even now, as we are watching, attempts in Georgia to overhaul the election system, and disenfranchise Black and Brown voters. Now, Maryland, that isn't the case. The General Assembly has made it a priority to, work to combat any attempts to suppress the vote. You all have championed reforms that have increased access to voter registration and voting overall. But even with all of these reforms, participation in the state is still low. And when we hear or when we learn about issues that that voters are facing in terms of making their voices heard, it's overwhelmingly, Black and Brown voters that are experiencing the most obstacles, in our elections. My testimony kind of outlines some examples, but jurisdictions like Prince George's County, Baltimore City, even Charles County, where we learned that in 2018, a vote center completely closed down, to accommodate a funeral, and voters in that area weren't provided with an alternative option to voting. And as a state, we hopefully will be addressing this, but we continue to disenfranchise eligible incarcerated voters who are overwhelmingly Black. So we've still got a ways to go. We recognize that a lot of these issues are due to capacity and limited resources at the state and local level. And we do believe that election officials are working above and beyond to ensure that all eligible voters have access to voting. But but the state board isn't well equipped to really work to apply a racial equity lens when making decisions that impact specific groups of voters. And we believe that a position like this might help to start us, start getting us there. A position like this alone obviously cannot change our elections, but we do believe that if the role is well positioned within the state board, meaning that they have access to all the information that they need, that they are able to engage partners and so forth, that this person, can help us.
Antoine, your timer.
So we urge a favorable report. Sorry.
All right. Thank you, Ms. Antoine. Any questions for Ms. Antoine? All right. Thank you very much. Seeing no other questions, we are done with the hearing on House Bill 1249, and we will go back to House Bill 1289. Delegate Amprey.
Hello, thank you, Chairwoman and members of the Ways and Means Committee. My apologies for my tardiness, as I have 3 bills today, so I'm becoming a real delegate, as some would say. Today I'll be presenting on House Bill 1289. The purpose of this bill comes from my own experience in applying for a homestead tax credit and not even realizing that this system was in place until well after owning my home. And I think that what we have here is a bill that will work towards relieving that from happening to so many different people. It's clear there's a need for more education on the Homestead Act tax credit, as well as the need for efforts made by the state to ensure that Marylanders are taking advantage of the tax provisions available to them. Delegates, to the extent that we believe that there should be tax credits available to Marylanders who are buying a home for the first time, we must also equally believe that lawmakers must maximize their ability to access those tax credits. So what House Bill 1289 does is it mandates that homestead applications are sent to the State Department of Taxation at the time of sale. This way we put a system in place that ensures that Marylanders are not missing out by including an application for the tax credit in the contract of sale. In addition, 1289—
Sign in for me on, and then see if they had a question, I guess.
Delegate.
All right, keep going, please, Delegate.
In addition, House Bill 1289 will require that SDAT will develop a single standardized form containing a statement that provides details, including eligibility requirements for the homestead property tax credit. Our work to provide essential tax credits is vain if we don't couple those efforts with adequate efforts to inform the public. And this will only be for new homeowners. I know previously there was issues with the possibility that people would take advantage and use this use the tax credit for their second and third home or vacation home. But this will be for first-time homeowners only that this application will be included. And lastly, what this bill will also do, and circumventing some of the issues that we face with displacement, a piece of this bill will also require the developers who are developing a piece of land that meets certain requirements as laid out in the bill will be required to inform residents about the process of which they can apply for the homestead tax credit. And the details in the bill details the parameters under which developers would be required to do so. And it would be required to give notice and let people know the ways in which they can ensure that they can protect their home from seeing excess arise in their tax assessment. So with that said, I want to keep it short and sweet. Ask for a favorable report on House Bill 1289.
Thank you, Delegate Amprey. Any questions for Delegate Amprey? All right, thank you very much, Delegate. We'll next hear from Lori Graff. I think she just signed back in. Go ahead.
Good afternoon, Madam Chair and members of the committee. I'm Lori Graff from the Maryland Building Industry Association. And respectfully, we had some issues with this bill, so we're testifying in opposition at the moment, although we're happy to talk about educating our buyers about the tax credits and the different things that you can get when buying a new home. We just have some concerns with the provision that requires the developer, when there's after 12 homes have been sold or have been developed, you have to basically inform everybody within a 1 mile radius of the development with a written statement that provides details, including eligibility requirements of the homestead tax credit. We don't see really the nexus between us developing this land and the homestead tax credit for the surrounding community. It doesn't really, there's no real relationship there, except for the fact that we're developing. And, you know, again, it's one thing to inform our buyers of the tax credit, but we have really no way of figuring out who in the surrounding community is eligible for this tax credit. It also could be quite costly to either, there's a provision that we have to make a good faith effort to identify those that should be provided the statement, as well as do some kind of confirmation of delivery or return receipt or that type of thing. And that can just be quite onerous on the developer. And, you know, again, we'd be happy to talk about ways to inform our buyers in those communities, but to have to do it within a 1 mile radius of those communities is somewhat onerous, and we don't think that's the best way to move forward, and it could have lots of complications for the developer. So for those reasons, we oppose this legislation at this time. Thank you.
Thank you, Ms. Graff. We also have Jason Weintraub.
Thank you, Madam Chair, Vice Chair Washington. Good afternoon, everybody. I think Ms. Graff summed up MBIA's concerns well. I would just point you to the fiscal note in the additional comments section. DLS has raised some implementation concerns as how this would work as well. So with that, we respectfully ask for an unfavorable report. Thank you.
Wow, I think if he's, I don't know if Mr. Connelly is still here, but I just think you beat his best time on short testimony. All right, and then we next have Susan Mitchell.
Good afternoon, Madam Chair, members of the committee. Susan Mitchell here. As we previously testified, the homestead property tax credit is one of the most important tax benefits for principal homeowners, and we appreciate the sponsor's intent. We, however, respectfully urge an unfavorable report. We believe, as we had testified earlier, as opposed to an addendum or statement, we believe including notice within the residential contract with a paragraph may be the better way to do it. And with regard to a mandated statement, we believe title companies could offer something at the time of settlement. We're happy to work with the sponsor, but we are opposed to the bill as currently written. Thank you.
Thank you, Ms. Mitchell. And is Robert Enton here as well?
I think he was just providing coverage, Madam Chair, on behalf of MBIA.
All right, thank you so much. Are there any questions for Mr. Weintraub and Ms. Mitchell? All right, thank you all so much. Thank you, Delegate Amprey. To members, we're done with the hearing on House Bill 1289. We'll next go to Delegate Lasanti, House Bill 1228.
Thank you. Thank you, Madam Chair and members of the committee. And I apologize for earlier, literally have a bill in another committee. So we were a little challenged here. House Bill 1228, Election Law Ballot Drop Box Prohibited Acts. The election law article defines election equipment. However, a drop box is not specifically enumerated in the current law. So House Bill 1228 defines a ballot drop box as a secure, durable, outdoor container that officially designated by the Board of Elections exclusively for voters to deposit a completed absentee ballot in person. Farther, this bill assigns the same prohibited acts such as removing, defacing, damaging to the ballot drop box, and the same associated fines and penalties that currently exist in law for violating election equipment. This is an important bill that updates Maryland's election law to ensure security and integrity of the cast ballot. I believe it is our responsibility to trust our election system. Therefore, securing the ballot box is critical, and I ask for a favorable report of House Bill 1228. Thank you, Madam Chair.
Thank you, Delegate Lasanti. Any questions for Delegate Lasanti? All right, thank you, Delegate. We're done with the hearing on House Bill 1228. We'll move to House Bill 1306. Delegate Lisanti.
Thank you, Madam Chair, and members of Ways and Means Committee. It's my pleasure to bring to you House Bill 1306. For the past 7 years, I've had the honor of representing the House of Delegates on the Maryland State Cybersecurity Council. If you don't know, the Cybersecurity Council was established in 2005 by the General Assembly and works with the National Institute of Standards and Technology, federal agencies, the military, private sector businesses, and private companies and cybersecurity experts to address state issues. The council is staffed by the University of Maryland Global Campus. It has some very simple responsibilities, basically to examine inconsistencies between state and federal cybersecurity laws and assist the private sector and businesses in adopting and implementing frameworks and good standards and practices, and recommending to us good legislative policy and changes. Over the past year, as the world has been on lockdown due to COVID-19 restrictions, America elected a president, members of Congress, while families learn to distance learn and distance work. The public's conversation has been focused on the cybersecurity of our election system and access to high-speed internet. Given the high level of technical expertise from academia, the public and private sector assigned to the Cybersecurity Council, I believe it is now appropriate to expand the scope of responsibilities assigned to the Cybersecurity Council. It is paramount that we assure Marylanders have faith in the outcomes of their elections and plan the necessary infrastructure for access to high-speed internet. Our daily lives certainly rely on that. A favorable report of House Bill 1307 would provide, very simply, an expanded scope of the Cybersecurity Council to include just a few things. One, monitor and evaluate the effectiveness and measures taken to ensure election security in the state, only from a cyber standpoint. Number two, monitor and evaluate the status of high-speed internet access in the state and recommend legislative changes to us so that we can make good policy. I respectfully ask for a favorable report on House Bill 1307. Thank you, Madam Chair.
Thank you, Delegate Lisanti. Any questions for Delegate Lisanti on House Bill 1306?
Oh, and I did want to ask, I'm sorry, I have also conferred, no, never mind. Sorry.
What's that?
I was asked to mention also that I did, that Comcast and had wanted to send a letter of support, but they weren't able to at the time, so they'll be following up with the committee.
All right, thank you. Mr. Cooper, Charlie Cooper.
Thank you, members of the committee and Madam Chair, and thank you to the bill sponsor, Delegate Lisanti. I'm Charlie Cooper, president of Get Money Out, representing our thousands of supporters who are concerned with equal access to the ballot. We support this bill because we think there are serious cybersecurity threats to our elections, and we just want to draw a distinction. There is a lot of talk about threats to elections. Some of them involve thousands and thousands of people doing illegal things. And there's no evidence in some cases that this is any kind of widespread phenomenon. And we haven't had cybersecurity threats to our Maryland elections. But the difference is here that one person or a very small group of persons with access to powerful computers and databases could crack into our computer system somehow, into our election machinery, into our voter database, into the communication between the polling places and the State Board of Elections, and cause real havoc. So the problem here is if we don't protect against this, instead of having a few instances where somebody did something wrong, like a voter voted twice, we could have tens or hundreds of thousands of voters' rights taken away by a cybersecurity threat that is actualized. So that's why we think this is a great thing to do, and we hope there'll be a favorable report. Thank you very much.
Thank you, Mr. Cooper. Any questions for Mr. Cooper? All right. Thank you very much, Mr. Cooper. Thank you, Delegate Lasanti. We're done with the hearing on House Bill 1306 and done with the bill hearing for today. For those who are worried, 17 bills done in 2 hours. Judiciary is working well past dinner time most nights. Any announcements for the good of the members? Announcements from the subcommittee chairs, Delegate Washington, Mr. Vice Chair?
Yes, thank you, Madam Chair. The Education Subcommittee will meet tomorrow at 12 o'clock.
All right. Any other subcommittee chairs have announcements?
Local revenues will meet Thursday at 1 p.m.
Anybody else?
Yes, Delegate, thank you, Madam Chair. Racing and Gaming will have multiple meetings today, the subcommittee work group regarding House Bill 940. On Wednesday, tomorrow, we will meet from 12:30 until 1:15. And then later that night from 6:30 until 8:30 p.m. And on Friday from 12:30 until 2. Again,
and that's on just a little bill, House Bill 940?
Absolutely.
Wagering. All
Thank you so much.
Any other announcements from subcommittee chairs? Or from any other members for the good of the group? All right, tomorrow on our only 10 to 12 bills, we have about 60 people signed up. So it will be a longer day for sure. Otherwise, I'll see y'all tomorrow. Have a good day or good night.